Okay, thank you very much, everyone. Thank you for joining us. We'll get started now. I'm Jim Stanford. I'm the economist and director of the Center for Future Work, which is a labor economics and labor policy think tank. We're associated with the Australia Institute. And it's my pleasure today to welcome you to our webinar on the Fair Work Commission and how we optimize its use of tools and possibilities to better value women's work, particularly in care industries. And we've got three excellent experts to join us to start a discussion, and then we'll have some audience questions and answers towards the end of our hour. Let me first start by saying that I'm joining the session today from the traditional unceded lands of the Gadigal people of the Eora Nation here in Sydney. And we want to express our solidarity from the Centre for Future Work for all Indigenous peoples and their struggles for voice, rights, and self-determination, and pay our respects to their elders past and present. And please take a moment wherever you're joining from to reflect on the land that you're meeting on and our struggle together for fairness and self-determination for Indigenous people. You're welcome to put something in the chat to that effect if you'd like. So glad that you could join us today to discuss the current state of play in better valuing women's work in light of the recent reforms to the industrial relations laws in Australia, new powers and tools to the Fair Work Commission in that set of issues, and then great timing. We're also going to get to talk about this historic decision on Friday from the Fair Work Commission about pay raises and other changes for workers in the aged care sector. So how it's going to work is we're going to have three speakers, and then we'll have some discussion amongst the three speakers, and then the last 15 minutes or so of our hour will be for discussions from the audience. And I do want to put attention on the Q&A button at the bottom of your screen. If you have questions that come up during the presentations, or particularly once we get to the discussion section at the end, please put your question in the Q&A box, and then I'll be working with our chair to make sure that we answer as many of those questions as we can in the time that we have. Now, I'm going to pass things over to our host for the session today, and it's my greatest pleasure to introduce you to Lisa Heap. Lisa is our new senior researcher at the Center for Future Work. She joined us last week, and we're so thrilled to have her as part of our team. Lisa brings an incredible wealth of experience in labor law, union organizing, advocacy, and research. And among other achievements, last Friday, the same day as the Fair Work Commission Award, Lisa had her PhD dissertation approved at RMIT. So congratulations, Lisa, on that. And we'll look forward to calling you Dr. Heap as soon as it's legally possible to do so. But at any rate, Lisa has great experience in the area of gender and work in all its dimensions, including work value issues, and has led successful cases for unions in Australia and in New Zealand on that very issue. So Lisa is going to chair our session today, and then she'll introduce our other two experts. So Lisa, over to you. Thank you very much.
Thank you, Jim, and welcome everyone. And I'm coming to you today from Naarm in Melbourne on the unceded lands of the Wurundjeri and Boonwurrung people of the Kulin Nations. And I'm looking forward to today's discussion in which we'll explore the role of the Fair Work Commission in both historically, first of all, undervaluing women's work, and also its potential now in terms of correcting that undervaluation of women's work. Of course, this discussion is even more pertinent, as Jim has said, given the handing down of the Fair Work Commission's expert panel's decision on the aged care work value case. And we are joined by Sara and Francis, and we'll be moving through these issues, and I couldn't think of two more expert people to have discussion. And as Jim has said, we'll provide a brief overview at this point, and then we'll have short presentations from Sara and Francis, a panel discussion with Sara and Francis about some of the issues arising, including the issues arising from the expert panel's decision, and then we'll have the Q&A. So don't forget to pop your questions and answers in there. So let's start with a brief introduction. And so I'm just going to share the screen for a moment, just for to show you a couple of slides, or one slide at the moment, in relation to this. Okay, so traditionally in Australia, fixing the gender pay gap and addressing gender-based undervaluation has relied on two approaches. The first, largely the encouraging employer approach, trying to convince employers of the business case of correcting undervaluation of work predominantly performed by women, and then also kind of encouraging them as part of that to do the right thing. And the second approach has been through taking equal pay cases to industrial tribunals. Unfortunately, as we know, neither approach has been successful. Pushing for pay equity through tribunals has been time-consuming and extraordinarily expensive on behalf of unions particularly, and these tribunals historically who have been historically oriented towards models of full-time male wage earners have had difficulty comprehending the problem of gender-based undervaluation of work. So the 2022 amendments to the Fair Work Act now give the Fair Work Commission stronger guidance and new tools to address the undervaluation of work in female-dominated occupations and industries. So what are these new tools? And just briefly, because Sara is going to go into these, the particularly important elements in detail, the suite of amendments to the Fair Work Act are aimed at promoting gender equality, including through ensuring equal remuneration and, importantly, eliminating gender-based undervaluation. And the Fair Work Act was amended to include a new overarching objective to promote gender equality as part of our workplace laws. And it also was amended to provide further guidance to the Fair Work Commission about the types of indicators it should use when dealing with, or the factors it should be dealing with, equal remuneration orders. A further new development is the appointment of experts panels to support the Commission in gender-related cases. And this is designed to ensure that gender experts are involved in reviewing modern awards, hearing equal remuneration, try saying that easily, cases, and the annual wage review. But perhaps one of the most promising areas, I argue, of the systemic change within the Act is in relation to gender-related problems, is the change to the Fair Work Act in the modern awards objective area. And Sara will go to that. This will require the Fair Work Commission to deal with modern awards in a way that will achieve gender equality by ensuring equal remuneration for work of equal or comparable value and eliminating gender-based undervaluation of work, and providing conditions of work that facilitate women's economic participation. So in the context of gender-based undervaluation of work, this amendment to the modern awards objective is important for three reasons. Firstly, particularly for those in female-dominated occupations, they are more likely to be reliant on award wages and conditions contained in modern awards. So it's more important that the awards are comprehensive and support a sustainable regime of pay and conditions. Secondly, if the Fair Work Commission invoked this objective to its fullest, it could bring about wide-ranging inquiries into the many factors that have contributed to gender-based undervaluation of the work predominantly performed by women. And thirdly, the amendment to the modern awards objective provides a mechanism to raise wages in female-dominated award areas across entire industries or occupations, and therefore could, circumvent the need, if the Commission was minded to do it, to have these case-by-case decision-making process. So there's plenty of opportunity for reform, and 2022 looks like it could be a big year. We've had the decision in relation to the aged care award work value case, the aged care work value cases. There are new applications already before the Commission that will be dealt with in 2024. The first by the nurses and midwifery, the the ANMF in relation to nursing and midwifery awards. And there is potentially other cases coming forward. There's also the review of female-dominated awards prompted by the Fair Work Commission, and research that the Fair Work Commission has commissioned for this will be considered as part of the annual wages review proceedings this year. So I'll end my introduction there and hand over to Sara to give us a bit of more insight into the detail of some of these important areas of change in the Act. So thanks, Sara. So to consider what the potential is of the Fair Work Commission, Sara is going to talk about the opportunities and promises within the Fair Work Act and what the Fair Work Commission can do. And so those of you who don't know Sara, I'm not sure that there are many people out there who are interested in pay equity and related issues who don't know Sara, but Sara is the Professor Emerita in the College of Business and Law at RMIT University, and her research centres on gender inequality in employment in the labour market, in industries and at the workplace levels. She has published and presented widely in a wide range of academic, policy and community fora, and has participated in key gender equality and industrial relations reviews and debates. And her current areas of focus include low-paid women's work, pay equity, paid cared work, migrant care workers and gender-based violence. Sara has been invited to provide expert evidence on these topics to government inquiries and to the Fair Work Commission. And amongst other things, Sara is part of the advisory committee for the Centre for Future Work. So thank you, Sara.
Thank you, Lisa, for that kind introduction. And I'd like to acknowledge that I'm also coming from Naarm and the unceded lands of the Boiwurrung and Wurrung peoples of the Eastern Kulin Nations. So my starting point is really, I suppose, that revitalising modern awards is in fact the best mechanism that the Fair Work Commission has to address the undervaluation of low-paid feminised work. Even with the 2022 gender equality reforms to equal remuneration and work value, these cases, as Lisa said, are still very expensive and also very time-consuming to run. So why focus on modern awards? Lisa's already drawn attention to one of the factors. Female-dominated work is characterised by high rates of award reliance. You see that, for example, 68% of those who work in social assistance services are award reliant compared to just over 20% of employees generally. And given the low rates of enterprise bargaining in feminised sectors, the paying conditions in those awards provide not only a minimum, but effectively a ceiling for the employees employed underneath them. Even where we see enterprise agreements achieved in low-paid feminised sectors, excuse me, in many cases there are meagre, if any, wage increases at all, which may in fact then have been traded off for more employer-oriented working time flexibility. A third reason is that the undervaluation of work in key modern awards in feminised sectors is characterised not only by low minimum award rates, but also by poor working time provisions, which facilitate working time insecurity, even for permanent part-time employees, and also by compressed career structures with inadequate skill descriptors and meagre relativities between levels. So Lisa, could you show that slide with the relevant legislation? Thank you. It's the next one. Yep, great. So in looking at the gender equality reforms I'm going to talk about, as I said, I'm not going to focus on work value or equal remuneration, but to the other key changes made in the same set of amendments, which in my view offer real promise in addressing the undervaluation of low-paid female-dominated work. So as you can see, the object of the Act now includes the aim of promoting job security and gender equality. Neither term is defined in the Act, but the explanatory memorandum says that the aim of including both is to put these considerations at the heart of the Fair Work Commission's decision-making. And further, that references to promoting job security are there to recognise the importance of employees and job seekers having the choice to be able to enjoy, to the fullest extent possible, ongoing, stable and secure employment that provides regular and predictable access to beneficial wages and conditions of employment. The references to promoting gender equality in the object of the Act are there to recognise not only the rights of everyone to equal rights, opportunities and treatment in the workplace and in their terms and conditions of employment, including equal pay, but also to recognise the policy objective of having both formal and substantive gender equality, that is, equality of outcomes. So in terms then of the modern award objective, which Lisa has flagged, has also been altered. This is important because Section 157 of the Act empowers the Fair Work Commission to vary a modern award on its own initiative or on application if it is satisfied that varying that particular modern award is necessary to achieve this object. So it's really of vital importance if we're really thinking about revitalising modern awards to achieve decent pay and conditions in feminised sectors. In the new subsection you can see there, it's not just about promoting gender equality, but in fact about achieving it through, as Lisa said, ensuring equal remuneration, eliminating gender-based violence, and also importantly, providing workplace conditions that facilitate women's full economic participation. What might full economic participation mean for workers covered by the working time provisions in awards such as those in retail and the care sectors, which currently facilitate employer organisation of work that leads to the fragmentation of working hours, both across the day and the week, even for permanent part-time workers, or indeed for those workers under these awards who are routinely underemployed, such as in aged care. In the current modern award review and in future commission own motion or its determinations, we also need to think about how this new consideration of gender equality might mesh with the additional objective of improving access to secure work. So as Lisa mentioned, the outcome of the current modern award review, which includes several of the key awards in low-paid feminised sectors, in one of its streams is specifically considering whether modern award provisions support the objective of promoting job security, which is clearly covered under the object, and the need to improve access to secure work across the economy. And in my view, potentially at least, these may offer better outcomes for more employees across this sector. Just looking briefly at the minimum wage objective, which is also, as you can see, reiterates the new objective of achieving gender equality. So while previously the Fair Work Commission had to take the principle of equal remuneration into account, this new principle fleshes that obligation out and brings in this requirement to consider eliminating the gender-based undervaluation of work, which will be particularly important in minimum wage panel deliberations. And this is very important, once again, if we think about the modern awards in the feminised sectors, because it's the national minimum wage increases that are really the only way for most workers that they will see their wages increase over time. So outside work value cases or equal remuneration cases, this is actually a key mechanism for improving wages. And there are some reasons to be hopeful about what the Fair Work Commission might do in its 2023 National Minimum Wage decision, specifically addressing this new gender equality consideration. It stated that there are significant issues concerning the potential undervaluation of work in modern award minimum wage rates applying to female-dominated industries and occupations, and the scope of the minimum wage review has prevented these gender equality issues being addressed to finality. I'm not quite sure why that's the case, but it goes on to say, the imperative of the amendments to the Act concerning gender equality is that these issues must be resolved in future reviews or in other Commission proceedings. So this, I think that is really promising. It's worth noting, and this is why I've included other considerations, the new gender equality consideration comes after the consideration that emphasises the performance of the economy and business competitiveness. So how will these two objects, if we just choose that one and the one about achieving gender equality, be balanced against each other? One could argue it's business competitiveness in the retail sector, for example, that drives the just-in-time rostering, which perpetuates the undervaluation and working time insecurity of the work performed. And finally, really in addressing the undervaluation of low-paid work in feminised sectors, a lot is going to depend on how the Fair Work Commission understands and interprets its obligations in respect not only of achieving gender equality, but also job security under the modern award objective, as well as in respect of its obligations in respect of achieving gender equality under the minimum wage objective, and how, as I've just said, these might be balanced against other considerations in both objectives. So I'll leave it there. Thank you.
Thank you, Sarah. And let's hope that the addition of some expertise from the expert panels can assist the Commission in considering how those things might be balanced into the future. I'll now go to Frances Flanagan, who is going to discuss the issue of historical perspectives on the role of labour law in supporting occupational status increases in Australia. The use in Australian labour laws of male comparators and benchmarks to fix wages was a central matter considered by the expert panel in the Fair Work Commission aged care work value decision. So Frances's presentation couldn't be more timely. So over to you, Frances.
Great, thank you so much, Lisa. And I'd also like to acknowledge that I'm on Gadigal country. So my reflections today are based on taking a long-term view of the idea of work value and asking the question of what we might learn from the way in which the concept was configured in the mid-20th century. So my purpose is not to suggest that the wage fixing principles that applied then apply now, but rather to stimulate ideas for future law reform at this very timely moment that Sara outlined. So I'd like to set out three key differences between the way in which the work value concept was understood today compared with 1961, which was when a masculine occupational group, engineers, used work value to achieve professional recognition and elevated status across dozens of different employment settings and awards. And they did so without any explicit reference to any other occupational group. They received on average a 25% pay rise, and this was applied regardless of differences between employers and their economic circumstances. So there are three reference points that the Commission at that time used to assess work value, and these are beyond the issues of skills, complexity and responsibility that are part of the current law today. So those three reference points were these: the needs and character of society, the needs and character of workers and households, and the needs and character of the occupation. So to start with society, it was crucial to the Commission's finding that engineering was of fundamental importance to the community, that the needs and comforts and defence of the community were said to be dependent upon his efforts, the engineer's efforts. The Commission received evidence from expert witnesses about the importance of engineering to society and the nation's productivity in general, and they made findings about the character of Australian society. They described it as being in a technological age where the needs of mankind continue to become more comprehensive and more complex, and that the know-how for the satisfaction of those needs was the responsibility of the engineering profession. They also said that a shortage of engineers constitutes a serious social problem and one that must be overcome if Australia is to make headway as a nation. Now, this approach was not an anomaly. Similar findings were made in the 1966 journalist case and the Metal Trades General Award of 1966. But we can contrast them to the situation today, where the Commission has made an assessment in relation to aged care within the coordinates of Section 157(2)(a), which it must. It's necessarily had to inquire into the nature of work, the level of skill and responsibility involved in doing work, the conditions under which work is done, and it must do so in a way that's free of assumptions based on gender and includes a consideration of whether historically the work was undervalued because of assumptions based on gender. Now, evidence of community expectations concerning care, so ideas around the desirability of ageing in place or person-centred models of care, these were brought as evidence, but they were relevant insofar as they concern changes in the nature and complexity of the work, not as dimensions relating to the character and needs of society in general. Indeed, in the second aged care work value case, the Commission categorically rejected arguments concerning social utility of work. These were considered to be value-laden and subjective and incapable of being accorded a numerical value, nothing more than a proxy requirement for carrying out a comprehensive assessment of work value. Arguments concerning attraction wages were also dismissed. I can return to those later in the comments. But the question of society was considered insofar as the Commission had an obligation to assess undervaluation relative to the value that work would be accorded in a theoretical society that was free of assumptions based on gender. And in the case, it did this by integrating the calculations performed in the Sachs case, where caring work was used as a proxy for gender-based undervaluation. Okay, so the second point is about character and needs of the individual worker and household as a reference point for work value. In 1961, the engineers argued that it was in the public interest that they had salaries that enabled them to maintain a standard of living and a status in keeping with the reasonable needs of the professional man. So this was an adaptation of the sort of harvester idea of the fair and reasonable wage. This was applied to a professional standard of living, which was said to entail a requirement that men had a car, a house, and a couple of decent suits. That they had a permanent place in the social stratum required to reproduce his kind emotionally, socially, and educationally. And the Commission not only made these findings, but also asked why it was the case that this status did not exist for engineers. And they made inquiries into the employment arrangements for the engineers, and found that engineers were more likely to be in employment than in professional practice in comparison to, say, doctors and lawyers. And this was the reason for their relatively, what was felt to be a low status. The Fair Work framework today is concerned, of course, with providing a fair and relevant safety net of terms and conditions. It must take into account, among other things, the relative living standards and needs of the low pay. And low pay is defined arithmetically, or has been by the Commission so far, as 2/3 of the median adult ordinary times earnings, a threshold that is reached in aged care at level 1, even after the 15% interim pay rise. So there's no scope, though, for an open-ended inquiry, or there hasn't been, as to whether or not the status of employees is appropriate to the social contribution they make. Indeed, evidence was led from employees about what they could be paid for performing different work in a non-aged care setting. And this evidence was rejected. It was found not to be necessary to take account of the subjective opinions of aged care workers. And not only is the Fair Work Commission not accepted that evidence, but they also haven't to date given a sort of general inquiry as to why, other than in relation to gender-based undervaluation, those wages are low. So, for instance, there's no consideration in the case about the role of what have been called public-private fissured arrangements. So that is where employees are employed by a private entity who receive public funds. And of course, this is the dominant paradigm for work in aged care, disability care, early childhood care, and others. So I would say those arrangements were introduced for gender-related reasons. They have a very powerful bearing on keeping wages at the level of award levels, as Sara outlined. They're also crucial to understanding the potential of work value as a basis for future pay rise, but at this stage, they haven't been considered by the Commission. Okay, so my third point is that work in relation to the character and needs of the occupation was also a matter that was considered in 1961. So the 1961 case was brought by a self-defined group of workers. They were drawn from a set of contexts of astonishingly diverse complexity and diversity and character. So everything from sort of telephony to civil aviation to Anglo-American oil. There were 60 relevant awards, 29 different employee representatives. They were a self-defined group. And of course, when they received award recognition, they could bargain on top of that. No estimate of the cost of their claims was presented to the Commission. So the ability of employers to pay was considered not relevant to the making of the award. By contrast, today, the contours of the occupations are determined by award definitions, which are quite capacious. But bargaining beyond the enterprise level requires, as we know from the supported bargaining stream, a special application. It's a highly conditional one. It requires making the case for the commonality of employer interests under Section 243(2), not employee interests. And as a consequence of that, so far, the applications we've seen have begun with just a small proportion of the workforce. So in ECEC, it's just 5% of the overall ECEC workforce has been in that application. Under the current framework, it appears that there's no scope for an employee-oriented group definition that transcends employer interests when it comes to bargaining. And of course, there's also no capacity to join the entity with power to the negotiation as of right. So the federal government, of course, supplies 80% of revenue in early childhood education and care. It exercises control over working conditions and qualifications, but it only has a third-party status that can be included at the direction of the Commission. So to sum up, in 1961, there were these 3 reference points for assessing work value that are functionally not part of our idea of work value now. And I think these guiding considerations would be valuable to consider as we move forward. We think about the law of work value at this moment of unprecedented openness within the Act, particularly in relation to occupations that are undervalued but aren't analogous to the Sachs case, where personal care perhaps is not the most central or dominant aspect of that work. Yeah, so okay, I'll leave my comments there for now and open to questions.
Sorry, you can see that I am getting used to this format. So to everyone out there who's ever had crises in these Zooms, I'm demonstrating what those crises look like. So thank you for your presentation, Frances, and my sincere apologies for not introducing you at the beginning. So for everyone who's just heard that brilliant presentation, I just wanted to reconfirm that Frances is Dr. Frances Flanagan. She's a lecturer at the in law at UTS or University of Technology Sydney, and she has an interdisciplinary, why am I getting all those dangerous words today? An interdisciplinary background in history and law, which I think makes Frances's research fascinating. And her research considers the intersections of concepts of labour, climate change, and technology. And it has been published in a range of academic journals, prior to going to UTS, she was at the University of Sydney, and she also worked in several roles outside of academia, including as a National Director of Research at the United Workers Union, formerly the United Voice, and as an Indigenous rights lawyer at the Yamaji Marlapa Aboriginal Corporation. And Frances is also one of the Centre for Future Work's esteemed associates. So thank you very much for your presentation, Frances, and my apologies again for missing that introduction. So what I'm going to do now is just share with you slides around the decision in the aged care before we go to the panel discussion. It's our intention here to just provide you with some headline information about the decision in case you haven't managed to catch up with it, so that you can understand the conversation that we're having about the aged care decision. So for those of you who are not who haven't been trawling through the decision like some of us have over the weekend, just a quick overview of those headline points, as I said. So firstly, importantly, I think for our discussion today and more generally for the work in this area, the Fair Work Commission did determine that the work of aged care sector employees had been historically undervalued because of assumptions based on gender. The use of the metal trades framework for aligning wages and fixing wages in awards was found to have been focused on male-dominated industries and occupations, and that this framework or approach had operated to inhibit the proper valuation of women's work across awards. The failure to properly implement that framework at the highest level, which is at the degree qualified level, or what's referred to as C1, particularly disadvantaged women. The expert panel also found that minimum wage rates in the Aged Care Award and the SHADS Award were fixed based on the gendered assumptions embedded in that historical middle trades alignment approach. and that the rates for degree qualified nurses in the Nurses Award were not properly fixed minimum rates because the federal awards system had failed to set minimum award rates of pay which properly recognise the addition to work value affected by the transformation of nursing into a profession. And in respect of direct care employees covered by all three awards, the expert panel was satisfied that there were work value reasons for the minimum award rates of pay to be, for those employees to be increased substantially beyond the 15% interim increase that it offered in its stage one decision. It determined that the way it would go about working out what the rates of pay should be would be to set a benchmark pay rate of a key classification, and then to construct a new and uniform classification structure using that benchmark rate. And it determined that the benchmark rate or the key classification would be fixed, aligned to those applying to Certificate 3 qualified personal care workers, assistants in nursing, and home care workers. The panel also proposed a benchmark rate for 4-year degree qualified registered nurses and for enrolled nurses acting as supervisors under the Nursing Award. However, it determined that it would not go further with the decision making in relation to that and would leave those matters to be further dealt with in the application that's been made by the ANMF to vary the General Nursing Award. I think significantly, the Commission, the expert panel determined that there was a fundamental difference between the work value of direct care workers and others engaged in residential aged care, so a separation between direct care and others. And this means that it wasn't possible to have a single integrated classification structure in the aged care award. And the purpose, and it found, contrary to what people have been arguing was needed, that that it wouldn't make detailed classification descriptors in the award, and that wasn't the role of classification descriptors in awards. And that the coverage of healthcare, home care workers should remain in the SHADS award, not be moved to the aged care award, but that the classification structure and rates of pay should be aligned with those personal care workers under the aged care award. And finally, in relation to direct care workers, that the personal care workers and assistants and nursing in aged care were functionally indistinguishable, and that there's no justification for them to be in two different awards, and therefore determined that it would move those that were covered by the nursing awards into the aged care award. In relation to indirect employees, I think less attention was paid to the issues associated with them. However, the Fair Work Commission expert panel found that they do not perform work of equivalent value to direct care workers that would justify them having their equal rates of pay as the direct care workers. And that however, that there were some areas of change of work value that needed to be noted, particularly associated with infection prevention, control measures, and dementia and aged care quality standards that should be recognised. And in recognising them, it offered them a 3% wage increase for indirect care workers. Some indirect care workers, those being laundry hands, cleaners, and food services assistants who interact with residents, were significantly more likely to interact with residents more significantly, and they were offered a further additional adjustment beyond the 3%, and that was basically done by changing the classification structure or alignment where they would be found under the current structure in the award. So it's, there's a lot to digest, and this is not the time where we'll just digest all of the implications of that, but just some of those issues for our discussion that come from that decision for our discussion today about the overarching approach of the Fair Work Commission I'll go first to Sara about, and then to Frances about what your overarching headline reflections are or impressions are about the decision. So Sara first.
Okay. Look, it's a very complex, multi-layered decision, and I gave expert evidence. So I suppose I need to think about how I'm going to phrase this. I think this is an important decision because it recognised that certainly for workers characterised as direct care workers that the 15% wasn't sufficient. I think the use, however, though, of what's called caring work to distinguish between both various types of workers, and the decision makes a lot about, if you like, about tossing out the metals framework baby, but I'm kind of wondering if we've actually tossing out the bathwater. I've got my analogy incorrect. We might have tossed out the baby with it. So it's really proposing more generally, and this will have implications for further cases, that there might be a case for different kinds of career structures, different and obviously then different pay rates in the caring sectors. Now, one can see that historically the metals framework has indeed, had a whole lot of problems. I'm not sure if those problems are answered by then creating a new, distinct, possibly ghettoising structure. And we see that most clearly in the distinction that's made between direct and indirect care workers. So I'll leave it there.
Thanks, Sara. And Frances, your headline thoughts?
Look, I agree with everything Sara said. I would just, add in a few additional observations. One is, I suppose, just again to recognise the significance. This is such a non-trivial wage rise. It will change the lives of thousands of people. And I think very valuable in this decision is just the way it comprehensively chronicles the path to non-recognition for undervalued women's work. The way in which we see that undervaluation was baked in through the structural efficiency principle, all those different directions. This is plainly written out now and will be a resource for decades to come. I think it also contains limitations, the limitations that are unsurprising, I suppose, given part of the framework of the Act that I sort of sketched. There's a very employer-centric view of staff shortages and work intensification and issues to do with attraction wages too that I would like to think some further about and unpack. There's a whole line of jurisprudence around attraction wages that pertained in the first half of the 20th century that is really important, but is not about the meaning of attraction wages in the sense of attracting workers to one employer rather than another, but rather ensuring that people have skills that they feel attracted to the occupation. And I'm not sure how well that idea of attraction wages was taken up in the decision, but it's a really, really important one. Though it was very bluntly dismissed in the case. Also, the real assumption that work intensification issues are temporary and will be addressed by the pay rises and temporary migrant labour, including labour agreements. All of this remains to be seen. There's a very hypothetical set of ideas. I would also just note, although the pay rises are very substantial, if you calculate an overall wage for a level 3 aged care employee, this is an improvement. It's still $66,000 a year. And in the context of a housing crisis, still really means that it's not possible to devote your career to aged care and have an expectation of living in a metropolitan area in a city like Sydney. That's not an appealing proposition, I expect, for a young person. And so I really feel like we need to think about the kind of social contract involved in how we value care work and what it means for a future generation and what kind of life course people can expect to have if they take this path. And it was precisely that kind of calculation that happened in the engineer's case, and it feels like we're quite a long way away from having a similar kind of calculation now.
Thanks very much, Frances. And both Sara and Frances, you've touched on thinking about the question to ask you, which is that, the implications of the deciding that in relation to this type of work, the benchmark would be back to another female-dominated area of work, and that we would perhaps start thinking there were two streams in relation to how award weights were set, one which is in the kind of male dominated in other areas, and one in the care work. So I think we dealt with that that potential there, and the concern that many of us were advocating that the metal trades framework was problematic in relation to valuing female dominated work. But the solution is there's a big question in my mind about where that sits, the solution that they've come up to that. So if we move on from that point, what about the issue about the fact that in the decision, there seems to be, in my reading, a heavy reliance on the fact that this that they can make this decision because the Commonwealth government has committed to funding the outcome from the case. So in a sense, that's introducing this idea that part of the decision-making process around undervaluation and correcting undervaluation includes this idea that that the cost to the employer or the capacity to pay might be coming into the decision making. What do you think about that? We'll go to Frances, you first on that one, and then Sarah.
Sure. I mean, I think the question of capacity and funding to pay is a matter that the Commission has to consider, like as a consequence of the Act. So the modern awards objective requires there to be a consideration of whether security of employment is endangered. Also Section C around the need to promote social inclusion through increased workforce participation. If pay rises are awarded through an agreement or that are not funded, there's always going to be the capacity for the employers to say that this is going to endanger employment, and therefore those provisions are not met. I think capacity to pay is also potentially relevant to the supported bargaining stream. So if we get to the point of there being pay rises awarded but not government funding to back them in, an employer who can't cover those pay rises may potentially be able to argue a change in circumstances and therefore be able to be withdrawn from a supported bargaining authorisation. So I think this issue really runs through multiple parts of the Act, and I think it's a real limitation in the way the law is configured. And functionally, it means that employee groups require a friendly government or require government to fund wage rises before pursuing claims. And that's, not ideally how we'd like the law to work. And I would also say it wasn't also the scenario that was faced by the engineers in the mid-century. So I feel it's an issue that really needs to be addressed.
Sarah, did you have anything to add?
Yes, I agree with Frances very much. But just to remind ourselves that the only other equal remuneration case that's got up under the Fair Work Act was the 2012 Social and Community Services Equal Pay case, which also literally, arguably, was written on the back of Julia Gillard promising $2 billion to the sector to fund pay increases, and then the decision was written after that agreement was struck. So this is not something that's new.
Thank you. I'm going to go to a question now from the audience because there's some lovely questions coming through. A question from Sandra Martin. Despite labour shortages, only 4% of support workers in residential and home aged care are employed full-time. Do you think, Sarah, that the Fair Work Commission can influence this to combat the insecure hours workers endure, or perhaps the government could influence this in their funding arrangements? There's a short problem for you to solve, Sarah.
Fabulous question, Sandra. And just to point out, in British Columbia, the provincial government has in fact decreed, at least in residential aged care, that this was a post-COVID measure and it's now in place on an ongoing sense, that residential aged care workers have to be employed on a full-time basis. This is a huge issue, and I suppose that's the point I was trying to make about working time security, so that even with the wage increases, if you're a part-time worker, you have guaranteed 10, 15 hours a week, that it actually doesn't mean very much in terms of increasing your rate of pay. So Frances, even if on annualised basis a worker gets $66,000, as Sandra says, only 4% of workers are employed full-time, and those who are working part-time are working short hours part-time work, which under the award provisions can be flexed up and down at ordinary time rate. So I think that the insecure hours are a huge issue, and it is my sincere hope that certainly in the job security stream of the modern award review, that at least for those awards and the major care awards. So if you think of the SHADS award, the childcare award, also the retail award, for example,
Yep.
large employers of women are in that review, that the job security stream of that, perhaps even more than the work and care stream, really considers the need to address secure hours and enough hours, because underemployment is a characteristic of female-dominated low-paid work. So yes, you know, as to whether or not the government could influence this in their funding arrangements, well, the British Columbia government, provincial government did, so why not?
Yeah, it's I think this does highlight the potential, if the Fair Work Commission has got the will to do it, the potential for it to use these new provisions to their fullest could make significant decisions. Francis, might go to you for a question. What do you think this is the potential of the new supported bargaining scheme or stream in the Act vis-a-vis these other changes? Which do you think might be? And that's a question that Fiona McDonald has raised.
Look, I think it's going to be interesting to see what happens. I mean, obviously there's a claim on foot. I think it's likely there will be, given that there's support from both the government, they've been joined as a third party to the negotiations. There's the employees and employers are all supportive of the process, that we will see pay rises there. My hesitancy around it as something that will provide an answer to the issue is foreshadowed in my comments before, which is that this is ultimately about the common interests of employers, not employees. And my worry is, as soon as pay rises become unfunded, that there's mechanisms for employers to remove themselves from the process. And I'm also mindful of the overall architecture of the way in which this industry is funded and operates, which is that this sort of public-private fishing dynamic, that means that employers are effectively disciplined by finance markets, that mean that they're bound to pay relatively lower wage. They're really constrained by the nature of the entity that they are in terms of what they can agree. So look, I think it sort of remains to be seen, but I would be very surprised if there is going to be the ability to kind of build out a whole sort of across sector wage rises based on the supported bargaining stream in comparison to a more creative use of awards in the way that Sara has outlined.
Thanks very much for that, Francis. I just note there's a question from Erica Hatfield in the questions, which is, do we know upon what factors were wages originally set for feminised industries? And I'll just point out to you that one of the good things about the decision, particularly from my point of view, is the summary of the history of how we've gotten to where we are in relation to wage fixing in Australia. And I think it's a really good starting point for people who want to get their head around, if you read the decision, what went on in relation to tribunal decision making around this thing. So do if you haven't had a chance to have a look at the decision in any detail, do put it under your pillow and hope to absorb the detail. But it does, for those that are working with students of industrial relations and labour law, it's a really useful summary as well. Okay, so I have a question about whether or not we really are seeing the kind of whether the way the Act is framed in particular provides us with the ability to move away from male comparators, but value things like what you've said as social utility, Francis, including social utility. Sara, how do you feel about that idea of the kind of broadening out, the including of new factors like or revisiting factors that have been contemplated in the past, like social utility, in the decision making of the Commission under this new regime? And what do you think are the potentials of that, and what do you think are the chances that might happen?
Well, look, I'll have a bit of a go, Lisa, but I'm afraid I know as much about social utility as Francis has elaborated for us today, and I've learnt a lot. I was wondering though, Frances, and perhaps this is a question back to you, the extent to which that concept is useful when you're talking about a living wage. We're no longer talking about living wages in Australia. We're talking about minimum wages. So we're not looking at, be it harvester or be it the engineer's case, we're not looking at wages that would be sufficient for the worker, whoever she is, to lead a dignified and, you know, albeit frugal, but a dignified life. So I'll hand that back to you.
Yeah, well, I suppose we still have a sort of residue of the idea of employee need when we have that modern awards objective concerning the needs of the low paid. For me, the problem is the qualification low pay as opposed to worker need in general. But on social utility, I will say that it seems as though the contraction away from the concept of social utility actually happened really early. So I mentioned, you know, a case from 1961. It was still very much alive as an idea in 66 and 67. When we get to 1968, the vehicle industry award decision, that's when the idea seems to have been codified, when the elements of work value were codified. And that's where the general notion of social utility of society seems to have dropped away. So at that point, we have an assessment based on the value of work to the operations of the plant as opposed to the operations of society. I think that, you know, there's a sort of conceptual point here, which is that when we think about something like work value, it requires a notion to not only correcting the injustices of the past, but also to be aware that like the needs of society are in motion and always changing, and some way of connecting with that, because obviously in an era of climate change, we have that sort of basic social infrastructure and ecological infrastructure is under strain. And we need a basis for saying that work that is involved with the reproduction of life, the secure creation of the conditions for life is valuable in that context because it is inherently valuable, but needed more than ever. And so I feel as though we need some element that takes account of the changing need of society that's only going to increase. And I just want to say one more thing about the way in which that idea was dismissed. Social utility was dismissed as being value-laden and subjective. I just want to say in all of work value cases, there's always been anxieties expressed by the Commission about the nature of the exercise as being arbitrary, as being imprecise, as being value-laden. You know, there were quotes constantly about plucking a figure from the air. And all I would say is that, you know, in many areas of law, we give numbers to what are non-quantifiable goods all the time. And if we resist the idea of what is value-laden, and what happens, we just default into market value, and market value itself has its own concealed values. So I feel as though this is a timely moment to not retreat from the ideas of values, but actually bring them to the surface and have them as a sort of openly debated idea.
Thanks, Frances. I think that's sort of like a rallying cry for us to be thinking more broadly. And sometimes it's useful for people who've been used to working within the system to hear those sorts of ideas, which have a historical base as well as, you know, can be reinvigorated for the here and now. And I think that you raise a really good point there. We are getting towards the end of today. And so I just want to wrap up. There's some great questions that we can continue to ponder in the question and answers, but what I will ask of our one final question of each of our presenters, and that final question is, what is the thing that you'd most like to see this year from the Fair Work Commission in relation to addressing the undervaluation of female-dominated work? So I'm going to go to you, Sara, first. What's your one ask? What's on your wish list this year?
Well, I think the issue that Sandra really brought up, I really think addressing the issue of working time insecurity is fundamental if we're going to really address the conditions of work in low-paid feminised sectors. So I would hope that that is given some weight in the job security stream of the current Modern Award Review.
Thank you. And Frances?
Oh, I would just say attentiveness to the idea of attraction wages and thinking about the older jurisprudence there, and some recognition of the significance of public-private fissuring, sort of locating that model of employment as an issue that is related to gender undervaluation, but is not reducible to it.
Thanks so much, Frances. Oh, thank you to you both. I can't imagine a more stimulating conversation myself, but that might be that I'm an IR nerd. But I think we've got in our midst this year, I think, the chance for something really significant to happen and for us to move beyond those small case-by-case adjustments in relation to this, the valuation of the work performed predominantly by women. And hopefully the Commission sees the moment in time and the historical moment it has before it as well. So thank you all for coming. Thank you to our presenters. Thank you to the fabulous thoughtful questions that there are in the question and answer session, and it gives us some insights into what we might have as future webinars here from the Centre of Future Work. And on that topic, just feel free for people to, if you have ideas for webinars that you'd like us to convene, contact myself through my email at lisa.heap@australiainstitute.org.au, and we'll be more than happy to look at those and look at our chances of putting on further webinars around those topics. And don't forget to follow the Centre for Future Work on our many socials to keep up to date with things that we're doing and things we're producing. I know that my colleague, Dr. Fiona McDonald, has got some important work coming out, analysing or highlighting again some of the key decision elements of the decision that need to be considered, and there'll be more work in this space coming from the Centre for Future Work. And just a reminder that the Centre for Future Work is an initiative of the Australia Institute, and it conducts and publishes progressive economic research on work, employment and labour markets. And it serves as a unique centre of excellence on the economic issues facing working people. And we look forward to your continued support. Thank you.